Good afternoon, everyone. I think we can now start. So I'd like to introduce the team that will be championing this webinar, and then we get on to the program for the day. So my name is Mr. Derek Amutavi. I am the Business Development Manager at Southern Tech Limited. I will be joined by a few of my colleagues. We have with us at the moment, you heard from her initially, Cynthia Chepkemoi, who is our Legal and Data Protection Officer at Southern Tech. We're also going to have our Data Protection Consultant, that's Mr. Philip Kisaka, who doubles down as also our guest speaker. And then we are going to have also another consultant of ours called Mrs. Brenda Gabantu B. And finally, we are going to have a discussant from the Office of the Data Protection Commissioner, Mr. Eugene, so that we get a voice from inside the ODPC. I know most of you have a lot of questions and maybe concerns on how the registration process is going. So I'd like to start by introducing this Southern Tech Limited, the company that has organized for this, so that each and every one of us gets to know the company who is hosting us. So Southern Tech is a registered corporate entity in Kenya, registered in the year 2019, incorporated in the year 2019. What we normally do is we offer managed ICT services. So we are a managed ICT partners for companies, public and private institutions, that is. We are a managed cybersecurity provider. Also data protection as a service provider, and generally we are a digital consulting company. Our mission statement is a data protection as a service provider, cybersecurity and managed IT partner of choice in a safe cyberspace for business. And finally, our vision is secure information technology and data services in a safe cyberspace, because data protection and cybersecurity go hand in hand. They are twins. Next slide. Now, that's just the general overview of the company. And now we'd like to go directly through to the subject matter of the day. That's now the data protection awareness sensitization, of which I'm going to introduce our guest speaker, Mr. Philip Kisaka, to start immediately. And then after that, Mr. Philip Kisaka will hand over to our Data Protection Officer, Cynthia Chepkemoi. And then we can have the session with the Eugene from the ODPC. So thank you for your audience. And I think I can hand the session over to Philip so that the education can start.
Because I'm a member of ICE, I've had the privilege to do a professional course, and a member of, and all these courses are just data privacy and protection related. So without much further ado, I'll just get straight into it. If you could move to the next slide kindly. Yeah, so when we advertise this on the link and the poster that was put out there, we put out a number of industries in the private sector specifically. That is education, ICT, finance, hospitality and tourism, security, healthcare, and finally SMEs. And one unique thing about all these industries is that all of them are data-driven organizations, and you ought to take proactive measures to enhance privacy in those spaces. You look at the education industry, not only are you saying that you'll be processing personal data, you're also moving to the extent of trying to think on how you'll be processing sensitive personal data, one, and two, personal data belonging to minors. And a lot of issues come into play when you consider that niche. Number two, looking at the ICT sector, definitely ICT and data integrate and relate in so many ways. You look at the finance sector, we are talking about credit history, borrowing data, all KYC documents that are normally provided within the whole finance ecosystem. When you talk about hospitality, again, you're talking about credit data, we're talking about location history and all that have you. When you look at security, we are talking about CCTV footage. How do you manage CCTV footage? How do you ensure that you're processing this data in accordance with the law? Then finally, when you talk about healthcare, again, the data within the healthcare industry is also very vast. SMEs is the last one because any of these industries can fit within the SME space. So as we continue to this discussion, just remember that we have tried to narrow it down, one, to C-suite executives, and number two, to business owners and business managers. So if you join the meeting and you're not in that category, you can stick to the end. However, today, most of our discussion will be centered around the responsibilities or the requirements around what this specific niche needs to do. Next slide, kindly. Let's begin by highlighting the Data Protection Act 2019. And I know by now most of you have already interacted with this act. You've listened or joined into webinars that have been discussing the Data Protection Act. You've already understood where it's all coming from and the necessity for it to be in place. But just to give you maybe a highlight for probably those ones who may have not interacted with it, the first thing that the act is attempting to do is reinforce. And by reinforcement, it's trying to reinforce Article 31 of the Constitution, which speaks on or provides for the right to privacy. And number two, it attempts to establish by introducing new rights that will be interacting with all through this discussion, the right to data portability, which says that a data subject can come to you as a controller or processor and ask for their data in standard readable format. We're talking about the right to access. Any data subject has the right to access whichever data you hold on that belongs to them. And number three, the Act attempts, or another objective is for it to empower. And it empowers players in this ecosystem, like the ODPC has been empowered by creation of that office. Much as we keep saying that it is not a very independent office, it still attempts to empower stakeholders within this whole ecosystem. It also attempts to empower the data subject by bringing back the power over your data back to you as a subject. And finally, it attempts to deter by imposing fines and penalties in case of non-compliance. So these are the four things that the Act throughout its reading attempts to do. We then move to now the three compliance domains. I mean, there are so many other domains, if you like, out there in terms of compliance, but I've reduced this into specifically three compliance domains, which will cover a range of things. Now, the first domain is on governance. And governance specifically involves ensuring that the person's information within the enterprise is managed in accordance with privacy, legal requirements, policies, procedures, guidelines, and data subject rights. And number two is on management. Management speaks more of the human resource aspect of who do you need to employ or recruit for them to be able to assist you within this compliance ecosystem with the data protection legal regime. Finally, we move to risk management. Of course, there's a lot of risk that comes with processing data, and within risk management, we'll discuss what a PIA is and a data protection impact assessment is. So a PIA is a privacy impact assessment, and a DPI is a data protection impact assessment. Of course, each one of them has different objectives, and each one of them is utilized differently. So we'll get straight into it. If you could move to the next slide. So on governance, as I had mentioned, we're talking about the legal requirements, the governing principles, policies and procedures, and the data subject rights. Definitely, at the end of the day, it is the responsibility of an enterprise to implement and support appropriate controls and to also enhance privacy throughout the life cycle of data. And you need to establish internal and external requirements for privacy programs within the organization. I've also proceeded to just list the internal requirements that you need to focus on as an executive, as a C-suite or a business owner or manager. And I've also highlighted the external requirements. But part of the very key, I'll just highlight two or three internal requirements. we have one, establishing a vendor management program. So most of us, or most people, think that data protection and privacy ends with you as an organization who's a controller or processor. But what this internal requirement is bringing out clearly is that you need to also focus on your vendors, such that if you have implemented procedures and policies as an organization, those vendors who integrate or who interact with your data, have they also adopted such similar or more, or even more robust principles, policies, and procedures? And number two is on performing privacy audits and assessments. And these ones do not need to be when you're anticipating an audit or a random audit by the ODPC. You need to continuously do this thing to always gauge where you are in terms of compliance at any given level. And on external requirements, we have documenting applicable laws, regulations, standards, and contractual obligations. Most lawyers love saying the law is very clear, but in data protection, I want to probably maybe assure you it's not very clear on so many things. So it really helps for you to document. Remember, again, one of the powers the ODPC has is the power to audit. Documentation just allows you to be able to show or sort of bring out the element of compliance, such that should you be found to have not complied or have complied partly, you're able to justify and say, hey, look, we may not be there yet, but we have attempted to at least comply. We can move to the next slide. The next slide is on management. And this includes establishing privacy rules and responsibilities related to data privacy training and awareness, communication, and activities, vendor and third-party management, privacy audits, and a privacy incident management capability. And the roles and responsibilities related to data are vast. You can have literally multiple departments and engaging with personal data, and specifically just to protect privacy. Of course, the senior most person at the top will be the data protection officer within the organization. But there are so many other support roles that go towards supporting this data protection officer. And then the hiring needs of this role will also just depend on one, your full capabilities, and number two, the size of your operations, and number three, whether you operate in one jurisdiction or you operate in multiple jurisdictions. So at the very top, you have a data controller or processor. Of course, that is not a hiring need. That is you yourself as a business, as a school, as an ICT provider, as a financial institution. You are most probably the data controller. Pardon me. Unless you are also utilizing a data processor to process on your behalf, then you'll also have to consider the need for a data processor complying with the same rules, procedures, and policies. And number two, we have the Chief Privacy Officer or the Data Protection Officer. Now, this is the top ranking officer in terms of deciding the whole general direction of the privacy department within the organization. And you're saying the overall responsibility, they have the overall responsibility for enterprise privacy management programs. And then smaller enterprises may not have a chief privacy officer, but you may have the role reporting to another C-level position. So this is the position that most organizations take. Further, as a data protection officer role, you can also decide to outsource it. Outsourcing becomes cheaper then because you do not need to hire supporting roles within it. You only need to contract an already established external DPO who's able to carry out the same functions as though they were an internal DPO. Then we have the Privacy Steering Committee. Now this committee, again, I'll just repeat that remember the need for these positions is only based on how big you are, the jurisdictions you operate within, and number three, your budget allocations for such a compliance activity. So there's a Privacy Steering Committee which is responsible for monitoring and reviewing to ensure good practices are identified, prioritized, and applied effectively and consistently throughout the enterprise. And you also need to consider, they also consider related ethical considerations for the derivation, collection, use, and sharing of personal data. And they provide input on how practitioners should use that data. So that is the responsibility of the Privacy Steering Committee. Of course, this is a committee that reports directly to the data protection officer. Then you have the privacy engineer, and the privacy engineer is responsible for creating and designing the requirements of privacy protection. So the privacy engineer, in contrast with the data protection officer, the data protection officer may have a legal background or an ICT background. But for the privacy engineer, because they are moving into the technical elements and aspects, then most probably you'll have to think of hiring someone who's more of a techie rather than a legal mind. Then you have the privacy management architect. This one, his responsibility is creating the plans used to build the processes that support effective and efficient privacy management within products and services through the enterprise. Again, this is a role that would most likely be utilized by bigger organizations that have multiple products. So you'll be finding that you have a privacy management architect for product A, you have another architect for product B, for product C, and so on and so forth. Then you also have a privacy manager. This one manages specifically assigned scopes of privacy management, program activities, and supporting efforts. For large organizations, again, you find that you may have a number of privacy managers within the organization just to support various activities within the organization's ecosystem. You have the Enterprise Risk Management Committee. This one is tasked with enterprise decision-making, specifically on risk management. They also set frameworks for how to collect, access, control, optimize, finance, share, and store data. Then finally, they monitor privacy risks from all sources. Down there you have the data processors. You also have the business unit manager. The business unit manager is sort of the lowest unit within this whole ecosystem. And these are the people who is the enterprise members responsible for ensuring that privacy is appropriately addressed and mitigated by their direct reports. They also ensure employees address privacy issues according to enterprise privacy policies and procedures related to their business areas and activities. We can move to the next slide. Privacy risk management. Now, when I began, I talked about privacy risk management. Yeah, thank you. When I began, I talked about privacy impact assessment reports and data protection impact assessment. So an enterprise privacy risk management framework consists of these elements that are on the screen. Number one, the purpose. And this just explains why privacy governance, what privacy governance goals entail. And number two, we move to the scope. Here we're going to be defining the personal data required to be protected and the internal policies to be followed. It is always very good to have a data inventory or to inventory a data inventory so as to be able to have visibility over which personal data requires protection. Then we move to risk. Here we'll be identifying potential risk factors, vulnerabilities, and threats related to data processing activities. Then we move to responsibilities. This is setting up a privacy committee consisting of identified stakeholders, specify the role of each department, establish the role of a data protection officer. So basically, we're just talking about what the second domain has taken us through. Then we finally move to processes, where we'll be establishing privacy risk management processes, incident management response, PIA, how to conduct a PIA, and how to conduct a DPIA. We can move to the next slide. So even before we move to the next slide, I promised to talk about a PIA and a DPIA. So a privacy impact assessment is an analysis of how personal information is collected, used, shared, and maintained for a specified scope of consideration. This, in contrast with a DPIA. A DPIA is only conducted when you are processing or you want to engage in an activity that is a high risk to personal privacy. A PIA is a normal audit done on a regular basis just to establish whether, as an organization, you are meeting your compliance obligations. And you need to conduct them as and when required, so as just to ensure that at any given point, if the ODPC decides to quote unquote raid your office and ask or seek to see how you are attempting to comply with this law, then you're able to show that, look, for these activities that are a high risk to privacy, we have done DPIAs, these are the reports. We also do regular PIAs, or maybe annually or biannually, and these are the reports that we have gotten from these audits. But now finally, almost finally, we get to the compliance journey. And the compliance journey has a number of elements. These are 5 elements. The first one is setting leadership and governance. Now, leadership and governance will definitely come from the C-suite level or the business owner. At the C-suite level, you're sitting at a board maybe, and you're discussing that this is the direction we need to go. And then this direction needs to be cascaded down to other staff. Number 2 is planning and strategy. So you need to plan on what kind of framework you'll adapt. Then what is your strategy as relating to data in your organization? Do you utilize data as yourselves? Are you processors who acquire that data and process on behalf of a controller? Or do you utilize data as yourself and also anticipate that you will commercialize this data and eventually end up selling this data? So you need to have a proper strategy in terms of how you manage your data. And number 3 is program and service delivery. This is where we're talking about now implementation. You have recruited the right people for those roles. You have come up with necessary policies of how to handle this data. And that whole, you will also come up with a DPIA template. I know the ODPC has given us a template sort of to follow through, but just have you adopted it to suit your organization? Then we move to element number 4, that is the complaint incident management. Of course, whenever there is data and there are subjects involved, there'll always be complaints in terms of how their data is being handled. There'll always be complaints about them receiving unwarranted or unwanted promotional messages and all that. This element is very important because this one determines whether a complaint will be lodged against you with the ODPC or in court. So you need to have a very robust and very thorough and specific complaint incident management plan. The number 5, as all other projects, is evaluation and reporting. Evaluate your framework and report on the gaps that you may have seen. Again, I'm not saying that this is a role specific to the EXCO, but then you need to also figure out how to outsource in terms of this whole 5 elements, because it is very hard for you to carry them all out in your individual capacity as a single business owner or without having expertise at the EXCO level. Or you can move to the next slide. So then, what are the roles of the C-suite executives and business owners and managers in enhancing compliance? And I've come up with these 5 or so roles. And the first one, again, as the previous slide had already indicated, is setting leadership and governance, which involves recruiting the right personnel or outsourcing and maintaining some roles externally, especially the data protection officer role. Because again, this needs to be a very independent role. So sometimes the law in regard to data protection may look like it is limiting business, because whereas you need to utilize data to make informed decisions, the law is saying you need to utilize this data within 1, 2, 3, 4 guidelines. So you need to have a very independent person holding that office of the data protection officer for them to be objective as possible at any given moment when giving advice on whether to carry out a project or deploy a program or not. Number 2, planning and strategy, which needs to be done at the C-suite level, then cascaded down to other staff through the chief executive, the MD, or whoever is leading the teams at that particular moment. This is very important because strategy is communicated from that top level. The rest of the organization will sort of follow that strategy that has already been decided from that top level. Number 3 is program and service delivery, and this involves the day-to-day management now. These committees that we've talked about, these managers that we've talked about, what are they doing on a daily? Or if you're not utilizing internal staff, if you've decided to outsource this whole role of data protection from an external organization, then who is the internal person responsible with integrating this with these external people in terms of providing direction and communication on behalf of the organization. So number 4 is the complaint incident management that we've talked about. And this falls specifically under the governance domain, specifically on subject rights. Subject rights, you have the right to access, and that is a subject access request. You need to respond within a reasonable time. We have a right to data portability, among others, so many other rights. So who is responsible to respond to this requests by data subjects? And number 2, have you put in place mechanisms to be able to respond to them on time so that you're not falling in the wrong side of the law? And the final one, as an executive, you need to regularly and periodically ask for reports that have been made specifically in relation to privacy-related matters, and that is the PIA. The DPIA does not really fall under here because the DPIA, again, is an activity that is carried out on specific occasions when and as needed. So then I'll give it back to Chepkemoi just to finish off. As we continue, you can always type your questions in the comment box. Then immediately after she finishes, we'll be able to maybe do a recap of this and answer your questions in the shortest time possible. Thank you very much for your attention. I hope you've gotten something, and I look forward to answering your questions. Chepkemoi.
Thank you so much, Philip. That was an interesting presentation, and yeah, I believe you've all learned something. So we'll move to the next category of the presentation, which is how we are going to help you strategize to achieve what has been mentioned earlier on. So at South End, as Derek had also stated earlier, we offer data protection services. And to achieve this goal, that is the legal compliance bit, we have legal consultants you can outsource to guide you through the process of compliance with the law, and also to enable you to achieve technical compliance as well. On to the second bit of it is that we also offer cybersecurity solutions, and I'm not going to go into the deep details of it, and it's also tied to the aspect of data protection as a service, because anytime you draft a privacy policy, you are required to apply the technical safeguards that you've implemented as an institution, even during the registration process. So one of the things that you realize when you're carrying on your registration is when you're filling out that form, you'll be asked what are the technical safeguards that you have in place as an organization to ensure that there's data security. So we also offer those services here at Southern. And thirdly, we also have services in relation to digital consulting generally. That is for e-government services. If you need a software to manage your products, let's say, for instance, an hospital, sometimes you get ill and you feel like, I should maybe have the doctor see me at home. So there are services in which you can access hospitals online and you are served at the comfort of your home, or prescriptions are provided. Moving on to the second bit of strategy is in every institution we have people, we have processes, and we have technology. And from the presentation made by Philip, it has come out so clearly that for us to achieve governance, management, and compliance when it comes to data protection, then all these three aspects are part of that process, and we cannot have one aspect dealt with and the other one has not been also well catered for. So in relation to people, we train and conduct simulations on data protection as a service and cybersecurity. And the trainings happen in three categories. We have the board, the C-suite level actually, which is also the board members who get trained on data protection. We also train the management. This include the head of departments, HR, finance, ICT, in matters to do with data protection. and the subordinate staff in our institutions. We also carry out simulations because every time they say, when you walk into an organization, the weakest link in any institution is the people. So if the people are not aware of what they have in the institution and they need to know what is important to us for our business to thrive, then we need to protect that data, which is data at the end of the day. Looking at processes, I believe Philip touched on this so well, policies, procedures, standards, and guidelines that the institution have in place in relation to data protection, and technology, which is the third and most important, but I believe people come first in my own right. So technology, this involves critical infrastructure, devices, software, hardware, and networks. And when offering cybersecurity solutions, it's meant to protect these devices from hardware, software, networks, and everything from threat actors. This could be a hacker or maybe just a malware being sent to you. So without the actual protection, which is the technical or maybe software that is required to protect this information, then it means the organization might get into trouble. So moving on, what will you achieve if you partner with Southend? The first thing and most important is legal compliance. And I believe there's a roadmap to it. We guide you through all that processes from being in a state where you are not compliant. We prepare documentation, and we as well work on how you are going to be compliant with the law to a point where when you sit back and look, when you sit down and look back, you realize that indeed something has been done and we are compliant with the law. We also achieve technical compliance, and having done the legal or having had the legal and technical compliance in place, it means that you are going to be able to proceed and carry on business, because at some point you feel like maybe the laws are too much, but that's not the case. Every time there's a need to comply, it means as a business, when you're compliant, then there's business continuity on your end. Yes, that's all for me. I'm going to introduce Brenda, Gabantu, and Eugene Odhiambo to take over the next part on answering your questions and concern in relation to what has been presented here today. Yeah, thank you.
We go straight to seeing a question by Winnie Gideon. She's asking, is a transfer impact assessment necessary when transferring data outside Kenya?
Yes, I think that. So a transfer impact assessment is probably a fancy term for DPIA, because you look at transferring of data outside Kenya, of course, involves a lot of high risk in terms of securing this data wherever you're taking it to. So a transfer impact assessment and a DPIA, a transfer impact assessment could form part of a DPIA. So yeah, it is actually very necessary.
Thank you for that.
Moving to the next question, I see a question. Is there a minimum number of staff complements to register as a collector or processor? From Frida, I think you're asking, okay, if I get this question correctly, you're asking, should you have a minimum number of staff for you to register as a controller or processor? Right, Frida? Or maybe if this question could be rephrased a bit.
Philip, I think we can move to the next question by Mr. Joel Ndongu.
Okay, regarding consent for collected personal data, Are organizations required to demonstrate consent for data that was collected prior to enactment of the Act? So I've received this question a number of times on data you already collected, you already processed before commencement of the Act. If the activity ceased, the processing activity ceased before commencement of the Act prior to enactment of the Act, but if the activity persists past enactment of the Act, then you definitely need to now comply and move forward to process this data within the confines of the Act. I hope that answers you, Joa.
Yes, it does. Thank you.
Someone, Timothy is asking. All right, thank you. Timothy Musuba, I think, is asking, is data impact assessment done prior to registration or after registration? So just to recap, there's two types of assessments. There's a privacy impact assessment and there's a data protection impact assessment. The data protection impact assessment is activity specific or program specific. So let's say you want to launch a new product and this product may or is a high risk to personal privacy, then you ought to carry out a data protection impact assessment. So I was saying data protection impact assessment is specific to activities that pose a high risk to personal privacy in terms of data. But a privacy impact assessment is conducted on a regular, just for you to gauge yourself in terms of compliance and for you to understand where you are and for you to carry out proactive measures within the whole organization towards compliance. I don't know if that answers you. So a PIA definitely needs to be done before registration. However, many people try to find ways to circumvent the questions that are being asked on portal. Speak directly to active have or should have been done prior to registration. DPIA is specific to activities that you will be carrying out.
Thank you, Philip. So I think we can go back. I'm seeing Frida Nganga has answered, like you had paraphrased her question, and she has said the way you paraphrased it is the correct body to the question. So I think she was asking if there's a minimum number of staff that that maybe meets that threshold to register.
Yeah, so yeah, on a number of staff, we talk about 10. Operating below 10 staff, then so first of all, if you're operating below 10, and sorry, yeah, so the is 10 staff members. But again, remember there are many other variables in terms of registration, bands. So the minimum amount for registration is 4,000, and then from 4,000 it graduates depending on your annual turnover and depending on the number of course, staff that you have within the organization. However, there are some industries that just require mandatory registration. I don't know if we have any slide on that. May not be there, but there are a number of industries like the finance industry. Basically, all industries that we stated on the poster: education industry, ICT, finance, hospitality, security, health. And this ones require you to mandatorily register. So whether you have 10 staff or less than 10 staff, you still need to register. But there are other industries that don't necessarily require you to register. And probably if you do not meet that threshold of staff or annual turnover, then you don't have to register. And moving to the next question.
We have a question by Damaris. If the data is transferred outside Kenya to be processed, do we need to alert the data subject if it's already mentioned in our terms and conditions?
So there are two conditions probably for transfer outside Kenya. One is consent. Number two is adequate safeguards in terms of that transfer. So it just depends. Would it pass the test for consent? The test for consent is that consent needs to be express, it needs to be explicit. So if you've put them in your terms and conditions, have you further like put a checkbox down there to say that you consent to your data being transferred outside Kenya according to these terms and conditions, and then what have you? So you need to meet those two conditions. One, consent. Number two is adequate safeguards. Derek, I see you skipped a number of questions.
Yes, so yes, we still have time, and
Yeah.
we can move forward. So this one from Winnie Ngige, what type of information should you? Yes.
Yeah, you skipped up there. I'm seeing one from Vincent Otieno here at 311.
Okay, I'm on that. So Vincent Otieno is asking, are controllers who process their own data required to register as both a controller and a processor?
Yes, unfortunately. So you have to register as both. Should you be carrying out both functions? You first of all register as either a controller, then move to register as a processor. I know there's a conversation on that, but so far, yes, you do have to register as both.
Probably we could get further clarification from Eugene from the ODPC on the same.
Good afternoon, team. Thank you so much for the wonderful presentation from South End and rest of the consultants and discussants. So just to add on what Mr. Kisaka has just presented, there's a wide discussion first to begin with when it comes to registration as either a data controller or data processor, or when an entity carries out both functions. But on our end, we will always advise that basing and putting reliance on the definitions of both, they are not the same. A good example just to give you can be, let's say, Safaricom, who on one end are data controllers and on the other end are data processors. When it comes to audits and the compliance aspects on our end, when we are conducting audits, we would like to see compliance on either side. When it comes to you having registered or you are a data controller, what are the safeguards that you've put in place as guided by both the Act and the regulations to ensure that you have passed the compliance or audit test? Looking at it closely, when it comes to the data processing or the data processor aspect, we will also be curious, what are some of the steps that, having shifted from the data control aspect, you have put in place as a data processor to process data? So I believe Mr. Vincent Otieno, that will answer your question. So where a controller is both a data controller and also a data processor, they need to register as both with us. Thank you.
Wow, thank you so much, Eugene, for that question. And I see that registration is one of the biggest topics we have with our participants this afternoon. My name is Brenda Gabantu, also a consultant with South End Tech. And I just want to take us through a brief session to engage Mr. Eugene from the Office of the ODPC on this same subject of registration. So, Mr. Eugene, I do know that registration is mandatory for most of the data intensive institutions, and I am well informed that most institutions we have participating this afternoon are heavy on data. So I would like to ask, there's a report that was released by your office on what's the status in regards to data, because Philip has told us that as part of our journey, there are certain things we need to do, and part of what we need to do is registration. So maybe you can give us a brief overview of what's the status in regards to registration by different entities that process personal data, and how far we are with that. Eugene?
Thank you so much for the inquiry, Brenda. When it comes to compliance and statistics from our end as an office, as at 2 p.m. today, basing on the statistics, we had 371 entities having the registrations approved and being issued with the certificate of certificates of registration, sorry. So you look at it, the number is up from what had earlier on been shared from the office, which shows an upward trajectory, though very, very demeaning when it comes to our own statistics. We compare that with the number of entities who have made attempts to log into our systems, which as at now stands to 1,435. Out of these 1,435 entities that have made attempts to access the system, only 915 have been able to log in, while we have 153 entities from the 1,435 that are pending, that have the applications pending approval. Out of the 1,435, 561 are still pending payment, with 492 entities having their registration in progress. So you look at that, do a quantitative analysis of the entities that have made attempts to access and have a look at the system, but have not either made attempts to log in or either follow up on their applications. So this goes on to the other aspects which my previous speaker, Mr. Kisaka, touched on. So in as much as the DPA has established the principles and rights, there are regulations in place urging and making it mandatory for entities who are either data controllers or data processors to register with the office for compliance purposes. This begs the question, what is the danger or what is the penalty for not registering? The answer to that will be, if you as an entity, be it a data controller or data processor, are engaging in data processing without having registered with us, then you are committing an offense under Regulation 18 of the Data Protection Registration of Data Controllers and Data Processors Regulations of 2021. It is within the knowledge that the certificate issued should last for 2 years. Upon the lapse of 2 years from the date of being issued, you are supposed to renew your certificate as either a data controller or data processor. Failure to do so will also be an offense under the previous regulation I had mentioned, being Regulation 18 of the Data Protection Registration as Data Controllers or Data Processors Regulations of 2021. So it is a collective effort. We know there is no deadline, strict deadline as at now, basing on both the Act and the regulations, but we call upon you as the data controllers and data processors who are in the private sector to make an attempt and put it among your key factors on the to-do list to have your entities register as both the data controller or data processor. And should you encounter any problem when being the same, you're always free to reach out to us on the emails on both the website and the contacts there. Thank you.
Thank you so much, Eugene. Actually, you've preempted and answered what I wanted to ask, and you've touched on the offense of non-registration and also failure to renew your certificate, which you can go through the penalties which are listed in Section 73 of the Act. And also you've touched on the ease of registration. I don't know if you can give a brief or an overview of what the participants need to do so that to be able to register. Maybe you can give them a 1 to 3 step on what they need to do on this journey as they plan to register.
Thank you so much for the question, Brenda. And I can see from the chat session, somebody has also asked a question closely related to what you just put up. I can see Mr. Timothy Musumba is curious to know how one gets to track the progress of the registration. Good question. So I believe that most of us in this forum are privy or have had the opportunity to go through our website and specifically single out the portal or the respective part of the website that deals with the data protection. So it is a simple 4-step or 7-step, depending on how you go about the same. So once you log in, you will be required to go through what is called a pre-registration process. Under the pre-registration process, you will be asked to identify yourself, whether you are you're making a first-time registration or you have already made the registration before. So for the first-time registration, this applies when you are accessing the system or portal for the first time. And you will be required to single out whether you are a data handler or what's commonly known as a data controller, or whether you are a data processor. So once you do so, there are 3 categories when it comes to registration. But for the sake of this webinar, being members of the private sector, then I'll dwell much on the private aspect of registration. So when you are conducting the registration at a private level, you can do so as an individual, as an institution, or under the 3rd category, which is others. So as an individual, you'll only be required to prove your maybe national ID and identify yourself. Are you a data controller or data processor? If you are an institution, then you have to be registered under the BRS from the eCitizen, because you will be required to key in that registration number. Then there's this other sensitive category of people called others, who are maybe circles, cooperative societies, or trusts. So once you identify where you fall on the respective category, you will move on to what is called the basic details column. So in the basic details, if you are from the private sector, there are a couple of sectors and subsectors in the drop-down menu where you'll be required to fill in the respective details. So the sectors and subsectors are based on data obtained from the Kenya National Bureau of Statistics. So it is a fully fledged drop-down menu with a wide range of sectors, be it banking, hospitality, all that, if you go through the same. So once you've gone through that, you will be asked, which is not mandatory, whether if you are from the sector or subsector that you've just highlighted, whether you have a data protection officer. So if you have one, you'll be required to key in their details. If you don't have, it's fine. We'll move on to the next step, which will be filling in of personal data. So under the filling in of personal data, you'll be required to identify the kind of data you are dealing with. After that, you will go to the next step where you'll be required to disclose whether you deal with any sensitive personal data. So if you deal with any sensitive personal data, you will key in the respective data from the drop-down menu. After that, you will go to a very key or crucial process or procedure under the portal, which is the transfer of data. So under the transfer of data, you will be asked whether you are transferring any data out of the jurisdiction. If you are transferring any data, then you will have to select yes. If you are not selecting any personal data, then you will say no. In the event that you are transferring personal data outside Kenya and you click yes, you will be required to enumerate or list any measures that you have put in place for the protection of the personal data which you are handling. So at that juncture, the system has a drop-down menu which attempts to identify the risks. So from the risks highlighted in the drop-down menu, if your entity engages or identifies another risk which is not listed in the drop-down menu, then you can type on the space that has been left behind. So after you're done, you've keyed in the personal data, disclosed any sensitive personal data, or you are transferring data and highlighted the measures of protection you put in place, then you go to the next bit of registration where you'll be required to disclose the employee and annual turnover. So as earlier on indicated, if you are an entity with an employee base of 10 and above, then you will have to pay the amount prescribed in the regulations, which in most cases will always be 4,000 as the minimum. Then when it comes to the annual turnover, you will be required to disclose whether the annual turnover is more than 5 million for you to be allowed to register as a data controller or data processor. While at this, there's this special category of entities who I believe some might be on this forum, who have an annual turnover of 9 employees and below, and have an annual turnover of less than 5 million. So if you fall under any of those categories that you have 9 employees and below and your annual turnover is less than 5 million, and you are among the entities who are referred to as those entities who engage in the activities listed under the third schedule of the Act, mostly pertaining to entities engaging in, let's say, political parties, crime prevention, gambling, education, health, hospitality, provision of financial services, telecommunication, transport, or business relating to genetic data, then you will be required to disclose the same and register, despite you having an annual turnover of less than 5 million and less than 9 employees. So after that, the system will lead you to disclosing your login credentials, mostly the email as a username and a password. Then after that, the same will be forwarded for verification on our end. Then you'll be asked to make payment through the 3 key ways, either via bank, check, or M-Pesa. Just to note, with having in mind time is up, you are always free to make any amendments or edit the application before you choose the mode of payment and after you have already disclosed the number of employees. Immediately the invoice has been generated based on the number of employees and annual turnover. You will not be able to make any amendment to your application. I believe based on the short time I've captured the key aspects, and that's all from our end. Thank you.
Thank you very much, Eugene. And apologies, everyone. We've taken 9 more minutes of your time, but I really hope it was worthwhile. So I think we can wrap up. And I've seen a question. I think this one is, I'll answer that very quickly because it's from Winnie. It's not from Winnie, it's from Saul. Has the ODPC approved any persons or companies to guide institutions in their compliance journey? How do we as companies identify the truth from the quacks? That's a genius question to ask. So I'll just answer as follows. For companies like Southern Tech, you know, for us, you'll not be dealing with robots. You'll be dealing with private practitioners, people who are specialized in data protection law, and they will have the documentations and the certifications to prove their expertise, and also they generally be able to demonstrate that they are experts in privacy and data protection. And also the company will need to provide compliance documents and registration formalities, the normal ones you normally have. So I think that's that. And I really appreciate your audience. And we wish we could go and on, but we are here for you. So in case you have any questions or concerns, I've put my number there. And then you can reach out to us, or you can follow us on our social media platforms. Our details are there, our phone numbers, our emails, and then we can work on how we can lead you to compliance going forward. And then hopefully we'll meet when we organize another webinar, and then we grow together as a country and as an industry. So I think that will be all from Southern Tech, and thank you for joining the webinar. And I hope to hear from most of you soon. You know, we have your data here. We wish we could, after the webinar, we could contact you and advise you on how we could lead you, but basing on the new Data Protections Act, it's illegal for us to do that. So it will be up to you to come to us for advice should you need our services. That's also part of the Data Protections Act, if I'm not wrong. So I think that's that. I think we can wrap up, unless we have closing remarks from Cynthia or Philip.
I don't think I have any closing remarks. I've seen a number of questions. We would have wished to answer them. Maybe we can figure out how to set up some other platform to answer them, but I hope it was an interactive session, and at least we've understood a bit of what our obligations are as the C-suite, business managers, and business owners. Thank you.
Cynthia?
Mine, I'd just like to really appreciate the audience for staying put to the last minute. To our chief facilitator, Philip, thank you for the great presentation you made, and to myself as well. And yeah, Derek, yeah, that was amazing. Have a great afternoon. I hope we meet while we do business together. Yeah.
Brenda?
Thank you so much, participants and our colleagues from Southend. I would like to also appreciate Eugene for the wonderful insight he's given us on registration. I believe now we are at least somewhere in terms of our compliance and our journey. Thank you so much and have a great afternoon.
Thank you, guys, and see you soon.